we'd like to welcome you to this Spot the Risk webinar on French and Spanish private client issues for Scottish lawyers. Next slide, please. I am joined today by Alvaro, who is the partner and head of international at Buckles LLP. Alvaro is based in Buckles' London office. He's practiced in the area of cross-border private client work for over a decade. He is dual qualified as an English solicitor and a Spanish abogado, and is fluent in English, Spanish, and French. He is the chairman of both the British Spanish Law Association and the STEP Cross-Border Estates Special Interest Group Committee. He's also a former founding member of this committee of STEP Spain. And we're very lucky to have him here with us today. So thank you so much, Alvaro, for joining us and sharing your wisdom with us. I am Jessica Flowerdew. I'm one of the personal partners at Brodies based in Edinburgh. I specialise in all aspects of private client law, but I have a special interest in cross-border private client work. As a dual French-British national and a fluent French speaker, I'm particularly passionate about Franco-Scottish cross-border succession and estate planning issues. And I'm regularly invited to speak at cross-border conferences in France. And I sit on the Scottish Committee of the Franco-British Lawyers Society. I've also worked with Alvaro and many of his colleagues in all of the complex cross-border work that we do together. So today we're going to talk to you about some of the issues that we come up against in cross-border cases involving Scotland, France, and Spain. And the purpose of this is just to signpost some of the risks that crop up when we advise clients on estate and succession planning, where these jurisdictions that are very different from Scotland are involved. So we're going to look at 5 case studies where we're focusing on deeds of variation, forced heirship, executors, trusts, and taxation. So next slide, please, Rachel. So we're first looking at Jane's estate. So John is the executor of his aunt Jane's will. The will has worldwide application. The estate is substantial, and a considerable amount of UK IHT has been paid due to the status of the deceased of Jane as a long-term resident in the UK. After taxes, the residue comprises an apartment in Paris and a villa in Marbella. Both are currently on the market pending sale. And there are 3 beneficiaries of the estate in terms of the will. There's John, who's also the executor. There's Mary, who's John's mother. And there's Charles, who's Mary's younger brother. And Mary gets in touch with you because she wants her son to get her share of the estate. So Alvaro, I'm going to turn to you. And could you just talk us through what the issues might be here from a Spanish perspective in respect of the apartment in Marbella? What sort of problems might this give rise to?
Fantastic. Thank you very much. So from a Spanish perspective, one of the key issues is that deeds of variation do not exist. This is due to the fact that an estate in Spain is not administered, is a transfer of ownership between the deceased and the beneficiary. So what happens is that any alteration from or any deviation from what it is, the intestacy provisions or the terms of the will trigger a series of adverse tax consequences. So for example, what would happen is if, and I say if, the deed of variation were to be accepted by the notary and the land registrar, because these are the 2 bodies that will authorize the transfer, basically there could be an adverse tax situation, because in this instance, what could happen is that there could be a presumption that Mary has gifted John her share in the estate, in the Spanish property. And this could be an additional set of taxes. So there will be the Spanish inheritance tax that Mary will pay as a beneficiary, and then a second set of taxes that will be the gift tax that John will have to pay as beneficiary of Mary's entitlement to the property. The tax authorities in Spain are very inconsistent. I mean, in some cases, in the very few, they have accepted as a direct transfer. I mean, I've seen it very, very, very few times. the original beneficiary, but that the asset hasn't gone to the original beneficiary. And some cases, I mean, the few, very, very few, and this is many years ago, because now the tax authorities, they flag this issue very quickly. One other thing is, and going now moving from the tax, but entering into what is the legal point of it, because this variation, at least in England and Wales, are private documents. They are, just signed and witnessed, and they are not a public document. The notary and land registrar will be very reluctant with them, because they will say, well, hang on, how are you changing, for them, something so important? You're varying, the beneficiary is no longer the beneficiary, there is someone else. Why, how we're going to accept this? This is a private document, and this could be a potential issue that the land registrar may say, well, hang on, I'm not going to register this deed, I'm not going to authorize the deed, because the vital part, which is this variation, is done in a private document. We have to think that from a Spanish angle, only public documents have access to the land registry. So when we say public documents are notarial deeds or court orders, and the deed of variation in itself is not a court order that we could say, in an affidavit of Scottish or English law, this is a court order that varies or gives a certain entitlement. So there will be a lot of, not just the tax, but there will be a lot of persuasion to be done. So from a Spanish point of view, and I always highlight this with UK practitioners, is that if you're going to do a variation, try to avoid varying a Spanish element, because basically there are too many too many replies up in the air. The taxation being a very important part, and also the legal status on the second part, whether this is going to be accepted.
Thanks, Alvaro. I think we've talked about this before many times, but the same would be true in France, because the estate again is not administered in the same way as it is in Scotland. So beneficiaries are deemed to inherit directly from the deceased at the point of death. So that is the moment at which the inheritance tax position in France crystallizes. And the deed of variation would likely be treated as a second taxable event and treated as a gift on which gift tax would be due in France, because there's no such thing as a potentially exempt transfer. I've had a similar case to this that has come across my desk quite recently, and in that case we have actually decided that the beneficiary should, in sort of agreement with the French lawyers advising, but we have decided that the beneficiary should renounce their interest in the estate and disclaim their interest, as opposed to vary, because that is not treated as for tax purposes as a gift by the beneficiary to the people that are ultimately destined to inherit. The difficulty in this situation is that if Mary was to renounce her interest, it's likely, depending on the terms of the will, but it's likely that her share would fall into intestacy, and you wouldn't have any control about who ultimately inherits. So it is not obviously the same as a variation, and you would have to think about that before you take that course of action. But that is certainly the way that we have the way we've decided to proceed in that case. But the sort of, I mean, I'm sure Alvaro will agree, but the overwhelming message here is don't do it without checking first. Always work with an expert in the jurisdiction concerned and check first before you do something like this, because the implications of it can be really serious.
yes, it can get very messy if because once it is done, there is no undoing it is very difficult. And there are options like, for example, once the funds are in the UK. So, for example, when Mary sells the property, so for example, the proceeds of the sale could be gifted, or something could be done in the UK. I mean, I appreciate that France and the UK, you have a double tax treaty. Spain and the UK, we don't. So whilst there is exchange of information, I mean, it's totally different. So, for example, it is not unusual in a Spanish, when there is a Spanish property, that whilst there is a variation once the proceeds of the sale have been repatriated back, sorry, to the UK, that for the time being has not been a large issue, but doesn't mean that it can become an issue in the future, because effectively in Spain you have transferred the property to someone, and in the end in the UK the beneficiary of the proceeds of the sale is a different person. So this in the future may be a problem. At the moment it is not a major issue, because the tax authorities in Spain, they say, well, you have paid in Spain the taxes you have to pay. In the UK, which is, the parties are not Spanish tax residents. There is no further link to Spain. They are, vary in the estate. And, this, as I say, for the time being, it's not a major issue, but there are ways around it. Doesn't mean that, as Jessica was saying, we're not saying that Mary is stuck with no options. It's just finding the right option for Mary and John, and avoiding unnecessary taxes.
Absolutely, absolutely. I'm conscious of time and that we have a lot to get through. So, can Rachel, can you move us on? Thank you so much. So we're now going to look at Maria and John, and we're focusing here on the issue of forced heirship, which obviously in Scotland we are familiar with, given Scottish legal rights. But Scottish legal rights are quite a unique sort of set of forced heirship rules, and the forced heirship rules on the continent are quite different. And are different, particularly in France and in Spain, where there are pretty serious rules about not disinheriting your children. So we've got Maria, who's married to John. She is Spanish and he is Scottish. They met during a holiday in Spain. This is a second marriage, so they both have children from a previous relationship, but they don't have any children together. Maria has a flat in Madrid and she's got substantial funds and investments in Spain. And John has a property in France. Maria and John have made wills in which they leave their estates to one another. We haven't here addressed where Maria and John are based, but we are going to assume that they are living in Scotland. That's where they live, that's where their home is. So I'm going to ask you, Alvaro, to talk us through the issues here, and perhaps you could outline for our audience before you do just set out for us how we would determine from a Spanish perspective what the applicable succession law is here, given Maria and John's residence in Scotland.
Okay, so the applicable law, it's very important here in this particular case, because Maria, as we are assuming, she is only a Spanish national, and therefore she can, under the EU succession regulation, can only make an election to Spanish law, unless she doesn't make an election. And if she is habitually resident in Scotland, it will be a Scottish law that potentially could apply to her estate. In either way, as Jessica was mentioning, there will be forced heirship provisions that will be very different. For example, in Spain, it will be very important to know where Maria is from within Spain, where she has her civil residence, as we call it in Spain, because in Spain, to put it very simple, we have Spanish general law that applies to the majority of the territory, but we have regional laws that apply in certain regions like Catalonia, the Balearic Islands, and this is important because the forced heirship provisions vary. Under Spanish general law, it's 2/3 have to go to the children, not to all the children, but to the children. And in certain regions, like for example, in Catalonia, it is 1/4. So the difference is quite stark. But in any event, in the case of a spouse under Spanish law, it is a forced heir in a certain way, but has smaller or more reduced rights than a child. Because contrary to what happens in other, for example, under English law, that the spouse has priority over the children in an intestacy, in Spain, which is something that many people find fascinating, the children, even if they're adults, financially independent, will have priority over a spouse that is financially dependent of the surviving spouse of the deceased. So in this particular case, Maria, technically, I mean, if Spanish law applies to her estate, say that there is no, it is not clear whether she's habitually resident in Scotland. There could be, she could not leave her entire estate to John. She could leave him as a life interest trust, so he could have the use as a usufructo, which basically is similar to a life interest trust, where he could use and enjoy the property and and the income, etc., but not the absolute title. So this is something that Maria will have to bear in mind. Another thing, which is something that we are asked very often, is whether Spain would accept renvoi to, for example, to deal with immovable property. Now, what would happen here in this particular case, let's say that she is habitually resident in Scotland, and it is very clear that we can prove that that Scottish law will apply to her estate. Now, the Spanish authorities are very unlikely going to treat different assets in Spain with different laws. So at the moment, it is unlikely say that because the Scottish law would make renvoi to the Spanish immovable property to Spanish law. It is very unlikely that the Spanish authorities will apply Spanish law for the immovables and Scots law for the investment funds she has. So it will be a matter of getting all the parties sitting down together and seeing what they agree with, because the outcome, it will very much depend what Scots law says as to what the children get, because I think that Maria's children are not going to be very happy if they don't see if their entitlement is considerably reduced.
Yes, and and obviously we know that if Scottish law applies to the succession of Maria's estate, then legal rights would be in play, and if she has substantial movable assets in Spain, that those would be included for the purposes of assessing the value of the children's legal rights. So from a French perspective, again, if we assume that Maria and John are habitually resident in Scotland, then as Alvaro has told us, under the EU succession regulation, which is the law in force in France and in Spain, the default position from a French perspective is that Scottish law will apply to the succession of the estate, including to John's property. However, we've heard about renvoi. So as far as obviously Scotland is concerned, because the house is situated in France, it devolves in accordance with the law in France, in accordance with the law of the lex situs. And France, unlike Spain, France will accept that referral to French law from Scotland under the relevant provisions of the EU succession regulation, known as the renvoi provisions. So it's likely that unless John has made other arrangements, that French law will apply to the succession of the property in France. John could as a UK national, he could elect for Scottish law to apply to the succession of the House under the EU succession regulation. Um, so Scotland is the jurisdiction within the country of his nationality, within the UK, to which he is most closely connected. So he has that option to prevent the default position, to prevent the law of his habitual residence, and to prevent the application of renvoi, which would see French law apply to the succession of the property in France. He can try to sort of stop that from happening by making this choice of law election. And doing that is quite an attractive option for John, because he wants to leave his house to Maria. And in order to do that, he has to avoid the application of forced heirship rules in France, which, similarly to Spain, give a very great degree of protection to children. The amount the children get depends on the number of children that there are, and importantly, if a deceased is survived by children, then the spouse is not a protected heir in France at all. So children very much come first, and that is the case irrespective of whether they're grown up and independent financially. It doesn't matter. So making a choice of law election for those sort of UK nationals, for example, that have assets in France is one of a number of ways of making sure that you can pass your assets there to your spouse. And for many years, that's exactly what many people in John's situation would do. They would do a will. They would say, I would like Scottish law to apply to the succession of my estate. And that was fantastic. You could leave your house in France to your spouse, because Scottish law would apply. And of course, legal rights don't touch heritage. However, in 2021, there was an amendment to Article 913 of the French Civil Code, in terms of which France introduced a new law known as the Droit de Prélèvement Compensatoire, or the DPC. The DPC essentially reintroduces forced heirship in estates that are dealt with under a foreign law that does not have a forced heirship equivalent, by creating a right of compensation over French assets for French reserved heirs, so for the deceased's children, where those children are disinherited under the application of the foreign law. And this has had a very significant impact on people like John, in John's situation. The DPC would apply here if John, or at least one of his children, was habitually resident in any country of the EU, not just France, or was a national of any country of the EU, not just France. And also if the law applicable to the estate, so if Scottish law does not have a forced heirship equivalent. So let's assume in this case that one of John's estranged children is habitually resident in Ireland, for example. So the first of the applicability criteria for the DPC is therefore met. We have to consider here whether the DPC applies, and the children are going to get a share of the French property. So the question then becomes whether Scottish legal rights are a forced heirship equivalent, such that the DPC doesn't apply. In my anecdotal experience of dealing with cross-border Franco-Scottish estates, the notaires that I deal with are taking the view that the protection afforded to children of the deceased in terms of legal rights is sufficient to disapply the DPC. And that is because those rights are automatic, they're indefeasible, and the fact that they're sort of limited to movable property only doesn't change that sort of automatic nature of the protection. Whether a French court would agree with that remains to be seen. A French court might take the view that they're too restricted. but I think importantly, and it's worth mentioning this, what seems beyond doubt is that British nationals who are more closely connected to England as a jurisdiction and who've made a choice of law election in favour of England will face the full force of the DPC, provided the habitual residence and nationality criteria is met, because the protection afforded to children under the Inheritance and Dependence Act in England is very unlikely to be considered by the French to amount to a forced heirship equivalent. It's not automatic. Awards are made at the court's discretion. It just isn't going to be considered to be protection sufficient enough. So it's a very controversial change to the many French notaires and notaires in France are compelled to address it. They cannot ignore it in terms of the law. They must address the DPC. They must notify heirs of their entitlement under the DPC. And this is causing a lot of problems for sort of common law jurisdiction nationals who've got assets in France, holiday houses in France, and the like. And it's likely to be challenged at some point in the European Court of Justice. It appears to completely fly in the face of the EU succession regulation. And so, it may be with us for a limited time, but it is with us at the moment, and it does have a serious effect, and it is definitely worth thinking about. So again, I think the cautionary tale here is never work in a silo. If a client has got assets abroad, either in France or in Spain, you need to think about what law is going to apply to the succession of those assets and what impact that might have on your ability to leave them where you would like to leave them. And I think, Alvaro, you'll agree with me here. There are things that you can do.
Of course. It's as you were saying, Jessica, it's so important to have that to sit all the advisors at the same table from the very beginning, because basically there is always room for doing things, and sometimes what the client wants, which for example, they want to benefit someone in particular, can be in their detriment, because then you may have unhappy beneficiaries there's a lot at stake that they would battle. And I think it's always very important to sit down and and I fully understand that, especially in cases of complex family structures, that there are lots of ways around it. You can, for example, leave assets in usufructo or usufruit or other things. You can compensate children with assets in other jurisdictions, but it is very important to grasp at least, because cross-border estates is not about knowing the law in the other jurisdiction. It's about the questions one has to ask the lawyer or the professional in the other jurisdiction. So I think that there is, as you were saying, is not about working in silos. It's not looking at a jurisdiction individually. It's looking at the entire picture and having everybody sat down together, because there is the legal aspect and also there is the tax aspect, which can be as equally important.
Absolutely. So we'll move on now, Rachel, to our next slide, where we're going to look at Fleur's estate. And we're going to talk about executors, because we in Scotland are very familiar with the concept of an executor. There must be an executor to administer an estate, because estates are administered. And one of the fundamental differences between jurisdictions like the one that we work in and France and Spain is that in France and Spain, the office of executor is not recognised in the way that it is here at all. So and that can give rise to all sorts of issues. So in this situation, Camille is one of the beneficiaries of her aunt Fleur's French will. Camille's brothers, with whom she hasn't had much contact in the last 10 years, are also appointed as beneficiaries in the will. They're also due to inherit. The will does not, as is very common in France. The will does not appoint any executors. In fact, it would be very unusual to see a French will appointing executors. Fleur's, Fleur, she doesn't have any children. She's a widow. She's lived in France her whole life. Um, but she married a Scottish man, Alan, and she inherited a flat from him in Edinburgh. She also has property in France, and she was a very big fan of holidaying in Barcelona, so she bought herself a little apartment there. So she's got things in everywhere. So there's a lot to think about. So um, just to I'm going to come to you, Alvaro, about the flat in Barcelona in a second. But from a Scottish perspective, we will need to appoint an executor. We're going to need to get confirmation in Scotland in relation to the flat in Edinburgh, and we're not going to be able to do that unless we have an executor. And we can't rely on any part of Scottish law, so we can't use the Executor Scotland Act, Section 3 of the Executor Scotland Act, and confirm one of the residuary legatees, because this is a French succession and French law applies here. Because Fleur was domiciled in France and she was also habitually resident in France under the EU succession regulation, there's just no doubt that this is a French succession. So the first thing that we're going to have to do to confirm to the Scottish property is we're going to have to obtain an opinion from a French lawyer or a French notaire who is going to confirm, first of all, the validity of the will, and is also going to need to tell us who is entitled to the administration of the estate and is therefore entitled to the appointment of executor. And we will then have to use that opinion to apply for the executor to be appointed using the dative procedure, which is a bit like a sort of square peg in a round hole, because we're using a sort of Scottish administrative procedure to apply an executor who is entitled to administer the estate, even though estates in France aren't administered and they don't recognise the office of executor. So it's a very sort of strange scenario where you're just trying to sort of use the tools that you've got to make it work. It would be helpful. We could have more than one executor appointed, but it probably would be helpful for Camille and her brothers to agree who is to take the grant, and if they are estranged and can't agree, then and it becomes contentious, then there's going to be issues. There's going to be issues there if there's a fight about who's to be appointed. We then have to, once we have our executor appointed under the dative procedure, we then have to use the opinion that we have obtained already to apply for confirmation. We're going to need translations of all of the documents that are in French. So the will, for example, if the opinion's in French, we will need to have that translated. Anybody who's translating those documents will have to docket the original documents to confirm that the translations are true representations of those documents. And even though you have got a will and there's no intestacy here and French law applies and it's not a Scottish estate, you are likely going to have to obtain a bond of cation because Edinburgh Sheriff Court will see that you've appointed a dative executor and they will want you to obtain a bond of cation. And then you are going to have to go through the painful process of applying for that bond, which can be challenging in an estate where a foreign law applies. So it's really a nightmare, and it would just be so much easier if you'd had an executor appointed in that will. So again, the message is, let's not work in silos. Let's make sure that if there are assets in other jurisdictions. And the same would be true if you were preparing a Scottish will dealing with assets in France. You're going to be appointing an executor. Obviously, you're going to want to think about what the powers of that executor might be, how you'll be able to draft the will in such a way as to help with the administration of assets in France. So to be able to access, for example, assets in the UK, liquid cash to pay for French inheritance tax, which is due by the beneficiaries of the estate as opposed to by the executor. So you might want to give the executor power to do that sort of thing in France. So the same is true in reverse. And if we then look at the flat in Barcelona and fast forward a bit, Alvaro, so you can give us your view on this. So if we assume that Camille has been appointed, confirmation has been granted in Scotland, it's all been it's all happened now. She's sold the Edinburgh property, and she's divided the proceeds of the Edinburgh property amongst beneficiaries, and she thinks to herself, oh, I'd like to do the same in Spain. I'm going to sell the Spanish apartment in Barcelona and then divide the proceeds in my capacity as executor, and then divide the proceeds amongst the beneficiaries. Tell us if she's going to be able to do that.
Well, no. In short, no. Basically, but this is a very fascinating case because here you would be looking at the possibility of asking for a European succession certificate because there are assets in France and there is a French will and there is a Spanish asset. So basically what happens is, as Jessica was mentioning, in Scotland is very important, the role of a personal representative and executor. In Spain, it is not. So basically, the beauty of this situation within the nightmare that Camille is going to have is the fact that the Spanish estate can be dealt at the same time. We don't need to wait until the confirmation is granted in Scotland. And what will happen is one thing that Camille could do and the other beneficiaries is to obtain from France, which will be the jurisdiction that will be competent to issue the European Certificate of Succession, to issue this certificate that will enable the beneficiaries in Spain to deal with the Spanish formalities. And they will have to sign a deed of inheritance in which the Barcelona property will be allocated in the respective shares that they are inheriting. So if all of them are inheriting in equal shares, it will be divided in equal shares. Now, the problem Camille is going to have is that Camille, even if she's been appointed by the Scottish courts as a personal representative or an executor, she has no priority over her siblings to sell the property or call the shots basically as to what is happening. All of them must be in agreement to sell the property. And this can be a problem if the relationship is a bit sour or estranged, because they will have to agree everything, the price, everything. So this is where the civil law system is more rigid because it requires the interaction and active role of all the beneficiaries, as opposed to in the Anglo-Saxon system of having a personal representative that is the person calling the shots, basically. And it's something that it is very important to explain, I think, continental clients, to say the executor is, or the personal representative is, the key person here. You as a beneficiary, you have to take a step back and watch the other, and that's why it's so important to explain clients, especially continental clients, what the executor is, so they can all make an informed decision. And maybe the executor that they are thinking is a very nice person but terrible at administering assets. So is in this case is why it's so important, the right choice of executor.
Yeah, and that would be the same with the French property. The executor doesn't have any, isn't able to administer that. It belongs to the beneficiaries as soon as the death occurs. So so there's no administration, there's no right, the executor doesn't have a right to sell the property and then distribute the assets amongst the beneficiaries. The beneficiaries will have to be involved with that. There there are instances where if Scottish law applied, which obviously it doesn't in this case, but if Scottish law applied, there are remedies that you can seek from a French court to allow the executor to administer assets in France. But it is, it's an uphill struggle, and it's an expensive big deal to go through that. So it's just worth understanding that the office just isn't recognised in the same way as it is here, and we have to sort of work within that framework. Thanks, Rachel. Could you move us on to our next slide? So we have Arthur here. Arthur is a Scot. He's living in Edinburgh. He's always enjoyed escaping to sunnier climes for his holidays. And when he retired, he bought a house in the Côte d'Azur in France. And he also bought a villa outside Granada in Spain. And he has no immediate family, so he's prepared a Scottish will, leaving his whole estate in trust for the benefit of his nieces and nephews and their descendants. He dies, leaving his estate, unfortunately, including his properties in France and in Spain, to this Scottish discretionary trust, in terms of which no one beneficiary is absolutely entitled to any part of his estate. So, Alvaro, are there any problems with this from a Spanish perspective?
The opening line will be that trust and Spain should be never on the same sentence, only to say that trusts in Spain are not to be used. Spain does not recognize trust, so this is going to be the first point. This trust, this discretionary trust, will be an absolute nightmare in Spain, because basically in Spain, under our legal system, a person can only dictate what is happening to the next generation, to the next line of beneficiaries. You cannot have an asset that is going to be administered by a third party forever and ever until God knows when. So basically, here in this case, this is going to be a bit of a nightmare for the executors. Because what would have to happen here is that the property will need to be taken out of a trust and will need to be allocated to a defined beneficiary. So this obviously is not what Arthur wanted, but because, for example, there may be a very, very valid reason as to why Arthur decided to leave it this way. But the problem that Arthur's estate is going to have is that this property will have to be allocated to a certain beneficiary. The protection that a trust grants to the estate or to that asset in particular fizzles away, because that asset will be of that person. So that person, as a legal owner of the property, can do, or beneficiaries, because there may be more than one, there may be, they may be able to do as they think fit. So for example, they can sell, obviously they agree. So, I mean, you can potentially talk about placing charges on the property, so there is no non-disposal, for example. But I don't think this would work on this scenario, because at the end of the day, the property doesn't go back to the trust. So here it will be a matter of coordinating the Scottish advisors and say, okay, now the notary in Spain is not going to register this, because there has to be a defined beneficiary as an individual. What are your suggestions? So for example, I don't know, whether a deed of appointment or any other document that that the property will be taken out of the trust. It will be necessary to review the terms of the will, whether this is possible, not possible. At the end of the day, the notary and land registrar in Spain, who are, as I was mentioning earlier, the key people in the transaction, will be relying on a Scots lawyer that will have to provide affidavits of law, opinions, as you would do the other way around with, for example, with a probate registry with a French will or a Spanish will. This is the other way around. So you as a Scottish lawyer will have to explain very clearly what options do you have, like, for example, taking out of the trust, allocating it to this person, the powers of the executors, etc. This, again, is something that if Arthur had planning from the input from a foreign lawyer or a Spanish lawyer, would have been ideal, because we could have, Arthur could have done other things, selling the property. I know that he liked going to Granada during the Scottish winters. But the problem is that if he, for example, had sold the property and converted the money into cash, the cash could be part of this discretionary trust in Scotland and managed by the executor. So this is why perhaps if Arthur knew this beforehand, he would have taken different measures.
Yeah, and Alvaro, can you tell us, would there be tax implications associated with an appointment, a deed of appointment from the trust in Spain?
Potentially, yes. So basically, whilst I know that France has a very peculiar view on taxation of trusts, Spain has a different view on the basis that a trust does not exist as such as a beneficiary, and inheritance tax is paid by individuals, not by corporations or entities. So here, most likely what would happen, and is the tax authorities are, as I say, totally unpredictable. In a best case scenario, what they would do is they will treat these, I mean, with careful explanation from the notary, they will be subject to inheritance tax as beneficiaries, depending on the relationship that they had with the deceased. If they are nephews and nieces or more or far more remote relatives, they will have less tax allowances. The farther related you are, the lower the allowance is. So potentially they're looking at a large inheritance tax bill because they are nephews, nieces. So that will be group 3 under the Spanish tax system. So potentially you're looking at a large tax bill on the basis of inheritance tax. I don't think that here the tax authorities will be that evil to consider that there has been, as a deed of variation, that there has been that, like 2 transfers on the basis that the first transfer, in my opinion, could not take place because
The beneficiary didn't exist.
didn't exist in the first place. So you will have to have a very good opinion from a Scottish lawyer here explaining how it happened. And there is the possibility as well in Spain, although this is a bit of a long shot, you can make legally binding consultations to the tax authorities. However, the problem you're going to have is you don't know how long this will take for them to respond to you. And one final thing from a Spanish point is that we don't have certificates of clearance. So you will have to wait 4 years since the date you filed the inheritance tax return. And if you don't hear during these 4 years or after the 4 year and 1 day of filing, you can assume that the tax authorities are happy. Well, not happy. They're never happy, but they have accepted what you have contained in the return. Otherwise, they will notify you of any, assessment or, their or investigation as to what they think fit. But if you don't hear 4 years, after 4 years from the date of filing the inheritance tax return,
you're fine.
You're yeah, yes, you're fine.
So this is also pretty disastrous from a French perspective. Like the Spanish, the French do not like trusts at all. They are likely to take a very aggressive tax position on this because the trust is discretionary. They're likely to treat the trust as a beneficiary, but to treat it as an unrelated third party beneficiary. And like in Spain, in France, beneficiaries will pay inheritance tax based on the proximity of their relationship to the deceased and the value of the assets that they inherit. So the closer you are to the deceased, the bigger your allowance and the lower your rate of tax. The further you are away from the deceased, the lower your allowance and the higher your rate of tax. And if you are treated as unrelated, then you have no allowance and you pay a 60% rate of inheritance tax. So the French tax authorities may look at this and think, well, this is an unrelated third-party beneficiary, so we're going to impose a 60% tax charge on the whole French property. And a deed of appointment may then be considered to be a second taxable event if the trust is to be wound up, because it's a nightmare to have a French property in a trust. The French probably would register the trustees as owners of the property on the French land registry, but then they will be treated forevermore as the owners of those properties, of that property. So they will just they will just look through the trust arrangement completely. If you are on the French land registry as the owner of that property, it's yours. The trustees would then, for example, they if somebody died, they one of the trustees died, they would be treated as owning that property and therefore being subject to inheritance tax, and they're also going to be pulled into a really nasty reporting regime where they're going to have to make annual returns every year. They're going to have to report to the French tax authorities anytime anything happens with the trust. And they may also be subject to French wealth tax as well, depending on the value of the property involved. So it's really best avoided. I've just had a message from Rachel to get us to hurry up, Alvaro, because we've got one more case study to go. And then we still have to follow up some questions. So we're going to zoom through the last one. Rachel, thank you very much. If you can just ping us on to James and Sophia. There's just so much to talk about. This is the problem. This is in relation to taxation. James is married to Sophia. Sorry, I think she's called Anne there. James is married to Anne. They live in Glasgow. They've got 4 children. But then James's marriage with Anne breaks down. They get divorced. He loses contact with his children, from whom he then becomes completely estranged. He meets Sophia, who's a Spanish national. She's been living and working in Glasgow for a number of years. They decide to get married. They prepare wills, leaving their assets to each other. A few years later, they decide to up sticks, and because they need a fresh start, and they move to Sophia's hometown of Barcelona. James and Sophia completely cut ties with Scotland. They sell all their properties in Scotland, and they retain no assets here or anywhere else in the UK. And then James dies 2 years after the move to Spain. So Alvaro, over to you for this one, because this involves Scotland and Spain. Very quickly, what are the issues here?
Okay, the main issue is that Sophia is a tax resident in Spain, so basically, and there are Spanish assets. So Sophia, basically what happens is ticks 2 boxes. One is that there are Spanish assets, so that already triggers Spanish taxation, but also she's a Spanish tax resident, so this triggers the worldwide taxation that she's going to have as a beneficiary of the estate in Spain. So basically what is happening in this case is that James' worldwide assets, we appreciate that he has no UK assets anymore, but he may have assets in other jurisdictions, offshore jurisdictions, or wherever they are situated. They will be subject to Spanish inheritance tax. Here in particular, it will be that of the region of Catalonia, because this is where both were, because we are assuming that James was also a tax resident in Spain. So the internal rules of conflict in Spain, because we are divided in 17 different regions with 17 different criteria for taxation. So this is an absolute nightmare. So basically what will happen is, in this particular case, because James was a tax resident in Spain, so is Sophia, and they were living in Catalonia, it will be the Catalan tax authorities that will trigger this. Now, what is very important is, in Spain, we don't have full spousal exemption for inheritance tax. There are generous allowances, but there is no full spousal exemption. There is no election to be a domicile or a long-term tax resident. That's it. You are classified. You will have basically the allowance that spouses have, which, yes, it will be one of the most generous allowance in the region, because the spouses and children are treated the same for tax purposes in the majority of the country. So basically what will happen is that here you will be in a situation where, potentially speaking, in the UK, there is no UK inheritance tax, but in Spain, there is a Spanish inheritance tax that you cannot offset, because there is nothing to offset against, basically.
Yeah.
So this is, sorry, just go
ahead.
Oh,
sorry, please. Alvaro, and there may, if they're still considered long-term resident in the UK, there might also be UK inheritance tax as
Yes.
well.
Yes.
And obviously, no, as we heard from you earlier,
Mm.
no double taxation treaty.
Mm.
So only unilateral relief. And
Mm.
what about the forced heirship if that kicks in and the kids?
Yes, that could be a potential problem because, for example, if James say he's made a say a Spanish will and or and there is no room for arguing that there has been an explicit or implicit choice of Scots law or anything similar, say that he declares that he's habitually resident in Spain, then the children have an entitlement to the estate. So not that this renders the will invalid, but there will have to be adjustments as to what the children get, whether it is which law is going to apply to his succession, and within Spain, whether it will be subject to Spanish general law or Spanish Catalan, sorry, or Catalan provisions. That because again, these vary. In Catalonia, children are entitled to 1/4 of the estate or thereabouts, and in under Spanish general law is 2/3. So the entitlement of the children would vary. But here, for example, if depending on the wording of the will and depending on the possibilities of, because it's not a very clear case of, this is something that will be a lot of arguing from the children. It will very much depend whether Spanish law or Scots law applies. And the key point here will be the wording of the will.
Yep, yep. So again, it would have been worth James and Sophia just getting the right advice at the time at which they drew up their wills, and then when their circumstances changed so dramatically when they moved to Spain, it would have been appropriate for them and sensible for them to revisit that advice, because yeah, because they've left a complicated and uncertain situation for themselves. We perhaps have time for one question, and if we don't get round to answering any questions, we'll follow up. We will follow up afterwards. But Alvaro, this is for you for the Arthur Trust case study. Could in that scenario, could the Spanish property be sold and then the proceeds of sale funded to the trust or held in trust, or does the defined beneficiary have to sort of be nominated before any sale took place?
Okay, two things that we can very quickly, two things that can happen here. As Jessica was mentioning earlier, the property could be potentially registered in the names of the trustees for them to sell the property. This would be, in my opinion, the safest option because the trustees will have an interest in selling the property. But the problem is if they are unrelated parties of the beneficiary, says that they are like professional executors, they're solicitors, unrelated parties, there may be a very large inheritance tax bill. The beauty of this option, whilst tax-wise is potentially not very good, is that that the property is going to be sold. Now, the other hand is that there could be a deed of appointment or similar in which the property is transferred or allocated to the beneficiaries and then the beneficiaries sell. But the problem is that the beneficiaries become the legal owners of the property, and therefore basically what happens there is they may not want to sell, or they may enter into an argument, or you may have to force a sale. So here, for example, this has landed on my desk before. Normally what ends up happening is that the professional executor decides, okay, I know from a tax point of view, this is totally adverse, but I am protecting the estate. I am avoiding this pitfall. And in some cases, depending obviously on the difference in tax, to registering the property into the the trustee's name, and then them selling the property.
Great. I think that's all we've got time for. Thank you very much for attending this webinar, and you will be sent the recording after it finishes. Thank you.